All right, it's on cause number DC 1818044, Anita Alonso. We've already done announcements, so we'll go ahead and go forward with this. Mr. McDaniel, you may proceed.
Yeah, thank you, Your Honor. This is a motion for summary judgment. It's actually been sort of kicking along for about a year now. We previously had summary judgment granted in our favor. Motion for new trial was filed so that Ms. Haley could take the deposition of a fellow named Liddell Buggs. And Liddell Buggs is the principal of 316, which is also one of the defendants in the case. We did take the deposition, and then Ms. Haley has filed a supplement to her previous response that then attaches basically the entirety of Mr. Buggs's deposition. Although the reason for setting aside the previous motion for summary judgment was so that this testimony could be secured, this testimony actually does not change anything with respect to the merits of BPL's motion for summary judgment and FCL's motion for summary judgment. As you may recall, Your Honor, this transaction started with the acquisition by 316 of a piece of property, which is the subject of this lawsuit, from an entity called Final Four. BPL's predecessor in interest was called 5 Arch, and when you look at the documents, you'll see 5 Arch's name, but that's the predecessor for BPL. 5 Arch financed that purchase by 316, and the deed from Final Four Investments, which is among the summary judgment exhibits, to 316 was recorded on October 23, 2017. And in that instrument, basically, it reflects that a $192,000 loan was made by 5 Arch. And in addition, it specifically states the vendor's lien and superior title to the property are retained for the benefit of 5 Arch Funding Corp., a California corporation, and are transferred to that party without recourse to grantor. The next day, the instruments conveyance from 316 to Ms. Alonso was recorded, and there's no evidence whatsoever that 5 Arch had any knowledge of that particular conveyance. When 5 Arch ultimately found out that the property had been conveyed to a third party, it declared a default under the deed of trust under the due on sale provisions of the deed of trust and commenced foreclosure proceedings. This lawsuit then followed. And the efforts to foreclose were enjoined, and that injunction is still in place. Basically, from our standpoint, Your Honor, I think it is really undisputable that BPL, successor to 5 Arch, has a prior and superior vendor's lien and superior title, and it's reflected in the deed to 316, which was recorded the day before the instruments to the plaintiffs were recorded. So there's no issue that Liddell Buggs can talk about that addresses that. There's nothing with respect to anything that 5 Arch do or didn't know that affects that. The plaintiffs are charged under very clear Texas law with matters that are of record when they acquire the property, and they're charged with recitals in the deed to their grantor, actually in their entire chain of title. But again, it's very clear Texas law that the plaintiffs were charged with knowledge of 5 Arch's superior lien position. Consistently, the deed to Ms. Alonso is entitled Wraparound General Warranty Deed with Vendor's Lien. It says it right at the very top of that instrument that this was a wraparound transaction. And they may have chosen not to read this instrument. I believe that there may be language issues. I'm not sure if they speak English, but they're charged with the statements and instruments that they signed. So in that context, we've got the deposition of Liddell Buggs, and Liddell testified that he had conversations with a person named Edward Gonzalez, who he believed was an employee of 5 Arch at the time. Mr. Gonzalez had previously been an employee of 5 Arch. He was not an employee at the time of the conversations that Mr. Buggs was talking about. He was acting as a loan broker. We have that proved up with the affidavit of Spencer Weaver that's attached to our motion. But even if, Your Honor, whatever was said to Mr. Gonzalez is chargeable to 5 Arch, the only thing that Liddell Buggs said, not in connection with this specific transaction, but that generally that he had told Edward Gonzalez that 316 was going to be acquiring the properties and turning them around and selling them as part of these wrap transactions. So that's the testimony. There's no testimony that Mr. Buggs ever talked to 5 Arch or Mr. Gonzalez or anybody else about the specifics of the loans to plaintiff. There's no indication whatsoever that 5 Arch had any contact with the plaintiffs. There's no evidence that 5 Arch knew of anything that was ever said to the plaintiffs. There's no evidence that it participated in any kind of improper conduct. What 5 Arch did was make a loan to 316 so 316 could acquire the property. Under our motion for summary judgment, Your Honor, we believe that it is absolutely clear that 5 Arch was a bona fide lender for value without notice of plaintiff's interest. There's no evidence whatsoever that rebuts that. We've also asserted that BPL has a prior and superior vendors and deed of trust lien. And again, that's reflected in the actual recital in the deed to 316. And then finally, Your Honor, we've asserted that BPL is subrogated to the loans that were paid off when it acquired the property. In particular, 5 Arch's loan funds paid off previous indebtedness against the property of $151,432. So BPL is subrogated to those lien positions and is entitled to judicial foreclosure of those lien positions. And there's nothing that's been put forward by Ms. Haley or that was said by Mr. Buggs or that was said by any other witness that affects the merits of any of those 3 bases entitling BPL to summary judgment. The summary judgment, and Mr. George may want to talk about this in more detail, but it also moves for summary judgment against BPL and against FCL on a whole litany of different types of claims. There's a equitable estoppel claim. There is claims of fraud and negligent misrepresentations, claims of using a document by deception, claims of a joint enterprise, vicarious liability, conspiracy, and some sort of a concert of action claim. And there is absolutely no evidence whatsoever that 5 Arch engaged in any improper conduct whatsoever with plaintiffs, or that they were even aware of the specific conveyance by 316 to plaintiffs. And we took the deposition of Liddell Buggs. He didn't change that a bit. It was not part of the previous summary judgment record. We've now jumped through the hoops. We've allowed Ms. Haley to take that deposition, but it does not change the merits of our motion for summary judgment. And we believe, Your Honor, that we're entitled to summary judgment on all of the plaintiff's claims, both with respect to title of the property and with respect to the tort claims. And we're entitled to affirmative findings and declaratory judgment with respect to BPL's rights and its entitlement to both non-judicial and judicial foreclosure.
Response.
Morning, Your Honor. I first want to start with that 5 Arch is attempting to foreclose on this property because they're saying that the transfer of the property to the plaintiffs was an unauthorized transfer. So that is the basis of this pretty much entire lawsuit, is that this was an unauthorized transfer. Well, according to one of the parties, 316, Liddell Bucks, this was not an unauthorized transfer. And so Five Arches claimed to be a bona fide purchaser, well, bona fide lender, when they can't claim that because according to a party in this case who was dealing with their employee, which was Edward Gonzalez, and he was, according to Mr. Buggs, the vice president of whole loan trading and finance of Five Arch. He was communicating with him, and they agreed that the transactions that they were going to undertake were going to be seller finance. And so Five Arch is now claiming, kind of hiding their hand, saying, no, we were not involved. But according to Liddell Buggs, this employee, Edward Gonzalez, conspired with him to actually seller finance these properties, which there are 6 other properties that are currently in litigation with Five Arch and Liddell Buggs and other plaintiffs as well in Houston, that are nearly exactly the same situation here. So this is not the only case, that's one, but they conspired to seller finance a total of 7 properties that I'm aware of. According to the deposition, Mr. Buggs listed a total of 7 properties, including this property that's the subject of this lawsuit, that they were all going to be seller financed. Now, did Mr. Buggs specifically say who the victims of these situations were going to be? No, he didn't say that Miss Anita Alonzo and Joe Barbara were going to be the victims of them actually seller financing and not actually doing fix and flips. So no, that Five Arch may or may not have known that the plaintiffs specifically were going to be the victims in this case, but Five Arch was aware that that these properties were going to be seller financed, meaning they were going to have a buyer. So therefore, when Liddell Buggs transferred this property to the plaintiffs, it was not an unauthorized transfer that they're claiming. So and they're saying we don't have any evidence for that. Well, Mr. Buggs admitted that he and Edward Gonzalez discussed via email and phone conversations that these properties were going to be seller financed, although the documentations would read otherwise. And so I will have to respectfully disagree that Five Arch had no knowledge of these plaintiffs going to be a part of going to actually be transferred these properties. So that's one. And then not only that, all of the plaintiffs' documents, their loan documents, their general warranty deed, all predate Five Arches. So Five Arch, so my clients, the plaintiffs, had no knowledge of Five Arch involvement at all. None of their deeds or loan documents reference Five Arch in their deed, and also in the deed that transferred the property from Final Four to 316, where it said reservations from conveyance. It said none. It said for prior liens, it said none. In the deed that was given to my clients, it said for prior liens, it said none. Reservations from conveyance, it said none. So my clients had no knowledge that there was going to be a superior lien on the property. They would have never purchased the property had they known that someone else would have a superior interest in that property. And because Five Arch was aware, they cannot claim and they were aware through their employee, Edward Gonzalez, who was the vice president of whole loan trading and finance. They were aware that these were going to be.
So Ms. Haley, is this the testimony you're talking about from Mr. Buggs? This
Yes,
is
sir.
what you cite too.
Yes, sir. This should be. Let me see. You want me to give you the page numbers?
Well, I think this is what you cited to page 106. Is that what you're relying on, or?
Yes, so let me pull up. I'm sorry, y'all, I'm pulling up from my computer now. Yes, so it's page 101, line 8 through 14, and also 106, 3 through 14.
Okay, let me see 101. It's just talking about what these people's positions are. right, did you have anything else, Ms. Haley?
Let's see. And I mean, there are several other things that the, and as it relates to their subrogation claims, so according to when you're attempting to subrogate, you can't have it, it'll be unconscionable to allow a person or a lender to maintain a position that's inconsistent with one to which he acquiesced or from which he accepted a benefit. So they're attempting to subrogate themselves, wanting to be subrogated in this case, but they received a benefit from actually closing on this loan from 5R, well, with 316, they received a financial benefit as well. And so they're attempting to subrogate, but their position, it's inconsistent with what they attempted to accomplish in this case. And they accepted a benefit from that. So they, according to quasi estoppel, they're not allowed to do that. And it will be unconscionable for them to try and subrogate themselves to this, in this matter.
Okay, response.
Yes, two things, Your Honor. One, the evidence from Mr. Buggs appeared to be that Mr. Gonzalez was holding himself out as an employee of 5 Arch. And he referenced he was reading from emails. Clearly that was hearsay testimony. But the actual summary judgment evidence is that Mr. Gonzalez was not an employee at the time these transactions took place. But second, Your Honor, even if he was an employee, there's still nothing that was said by Mr. Buggs to Mr. Gonzalez that would somehow invalidate 5 Arch's lien position. Ms. Haley started out talking about this notion of this being an unauthorized sale, and I mentioned that as part of my opening as well, that basically when 5 Arch discovered that the 316 had sold the property to Ms. Alonzo, it declared a default and initiated foreclosure proceedings. However, Your Honor, that may have been relevant sometime before this lawsuit got filed, but the 5 Arch note was only a 1-year note. So it had already matured by its terms on November 1, 2018, before this lawsuit got filed. So whether or not 5 Arch knew that Mr. Buggs was going to turn around and convey these properties as part of wrap transactions is really irrelevant to the default and the basis for moving forward with the foreclosure. Again, the 5 Arch note was only a 1-year note and was due. And then finally, Your Honor, I really I want to join, and it's really not relevant to our motion for summary judgment, but all these claims with respect to conspiracy and wrongdoing on the very deed to the plaintiffs. It says at the very top, the first words on the instrument are wraparound general warranty deed with vendor's lien. There's absolutely no way anything could have been misleading or deceptive about an instrument that is entitled wraparound general warranty deed with vendor's lien. The plaintiffs may not have read that, but they're charged with knowledge of the instruments that they sign. And to Your Honor, it's clear Texas law that the plaintiffs are going to be charged with recitals in their grantor's chain of title. It's kind of a burdensome concept to think that people are responsible for information in their chains of title, but they are in Texas. And clearly in the final 4 to 316 deed, it says very clearly, it references the $192,000 loan that was made by 5 Arch. It references that the vendor's lien and superior title are retained by final 4 and are assigned to 5 Arch as part of that transaction. You don't get into any equitable considerations. The rights are fixed. And it's very clear under Texas law that the plaintiffs are charged with these recitals and this information. And then when you couple that, especially, Your Honor, if we want to talk about equities, there's no evidence whatsoever that 5 Arch knew of anything improper with respect to this or any other loans made by 316. And Mr. Buggs, to his credit, has taking the position that he did not do anything misleading or deceptive to plaintiffs, but that's this Ms. Haley's lawsuit against 316 and Liddell Buzz. From our standpoint, a loan was made. There's no question that the loan was made, $192,000 loan. There's no question that previous loans against the property were paid off. There's no question with respect to the recitals in the deed to 316. So, Your Honor, we believe it's clear that we're entitled to summary judgment.
All right, the court's going to deny summary judgment on this. So we have a jury trial here on January 5th. We can talk about that now real quick if you want to. We're not going to probably have, this court did do a jury trial a couple weeks ago via Zoom. We wouldn't be able to try this. On a case of this complexity, I guess we could do it via Zoom if everyone agrees, but otherwise we would probably need to move it back quite a ways. So what are y'all's thoughts on this?
Your Honor, I actually spoke to my client recently, and we can get with all the parties just to determine if everyone will be open, but she's open to doing, allowing you to be the jury. So, bench trial. So if everyone is open to that, then we can kind of get it in a little sooner than that. But I know Maureen last time, Ms. Kersey was saying that, I think her client wanted to definitely pursue a jury trial. So,
obviously, if there's anybody who wants a jury trial and you paid a jury fee, then it has to be a jury trial. So, but if it's, the Supreme Court orders say that I can go forward with these trials without consent remotely. I don't feel comfortable in a case of this complexity of doing that unless the parties all agree. Is that right, Ms. Kersey? You want a jury on this?
I haven't spoken to my client about waiving jury rights, so I would have to speak to him first.
It's up to y'all. If it's going to be a jury trial, it's not going to go forward on January 5th. I could reset it to February if you're willing to consent to Zoom. If not, I'd probably set it sometime in, October or November next year, just because we're so backed up. But do you guys kind of want to just talk to your clients and we can talk again on January 5th, or how do y'all want to do this?
Your Honor, I think one consideration for the timing, just for everybody and for the court's sake, is that, the taxes are not being paid on this property. I believe 2018, 2019 taxes, approximately $20,000 are due. Obviously I'll go to my client about, waiving a jury trial and getting this to trial as quickly as possible. But if we were to, push this back to November of 2021, there's, I don't know what the city of Dallas is doing, or Dallas is doing as to taxes and, in this pandemic era, but there's a chance that the property gets foreclosed on before we even get to trial. So there's an issue there that's should be considered by all parties, I believe.
So just so it's clear, the three choices: one is you do a non-jury, we can try it on January 5th. If you want a jury and you consent to remote, we could possibly try you in February. If we can't get an agreement that it's going to be non-jury or remote, then it would be set in November of next year. So that's just something, just so you kind of know what the parameters are. All right, guys. So I guess we will see you back on January 5th. If you could let us know, let Rhonda know if you guys all agree to waive a jury trial, so that we know that case is actually going to go. We'd want something in writing on that, just that all parties agree to the waiver, and we can then try it on January 5th if that's what folks want. Your
Honor, is there the possibility that there could be an order that addresses some of the specific claims? There's 4 or 5 tort claims that weren't even addressed in the response to the motion for summary judgment. To the extent that we could knock out some of the claims that were not addressed and are essentially undisputed, it would help to narrow the issues for trial it might save everybody a lot of time.
Yeah, if you guys want to agree to eliminate some claims, that's fine with me. But that's up to y'all. Anything else, guys?
Thank you, Your Honor.
Okay, yeah, just let us know what you decide to do, and we'll go from there. All right, let's go ahead and go forward with. I think we're here on the prove up. Is everyone still here?
Yes, Judge. Good morning.
Morning. Okay, let's go on the record on cause number DC 202647 Martinez versus Sam's East Inc. Counsel, make your appearance.
Victoria Niave, guardian ad litem for the minor.
Guys, you need to speak up. Ms. Martinez, do you want to introduce
Yeah,
yourself?
Ramona Martinez on behalf of defendant Sam's East Inc.
Ms. Guerrera, you need to unmute.
Roxanne Guerrero, I'm here for the plaintiffs, Juan Martinez and Maria Martinez on behalf of their minor daughter.
All right, let's go and go forward with the prove up. Call your first witness.
I'll
Your
be
Honor,
interpreter, Your Honor.
Oh,
We have an interpreter.
yes, we have agreed that Ms. Nieve go ahead and interpret for the court.
That's right. That was, I think we agreed to that last week. So do all parties agree that Ms. Nieve, although she's not a certified translator, that she'd be able to translate in this case? Anyone have any objection to that?
No objection, Your Honor.
No objection, Your Honor.
Ms. Nieve, do you object?
I do not object, Your Honor.
Okay. And you are fluent in Spanish, is that correct?
I am, Your Honor.
Yeah. I know you are, but just want to make it clear on the record. So,
Yes.
All right, let's go ahead and go forward. Call your, let me go ahead and swear in Ms. Nieve as the translator. Do you swear or affirm that you'll faithfully translate the matters in this case from Spanish to English, from English to Spanish to the best of your ability?
I do.
All right, let's go ahead and proceed.
Your Honor, at this time, we would call the mother, Maria Martinez.
Ms. Martinez, please raise your right, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Por favor, levante su mano derecha y jure que lo que su testimonio va a ser la verdad, totalmente la verdad y solamente la verdad.
Sí.
Yes.
All right, let's proceed.
Is your name Maria Martinez?
Su nombre es María Martínez.
Sí.
Yes.
And you have a minor daughter named Jacqueline.
Y usted tiene una hija menor de edad que se llama Jacqueline.
Sí.
Yes.
Her date of birth is March 12th, 2009.
Su fecha de nacimiento es el 12 de marzo 2009.
Sí.
Yes.
On March 13th, 2019, you and your daughter went to a Sam's Club in Dallas County, Texas.
El 13 de marzo 2019, usted y su hija fueron a un Sam's Club en Dallas, Texas.
Sí.
Yes.
And your daughter was 10 years old on that day.
Y su hija tenía 10 años de edad en ese día.
Sí.
Yes.
The two of y'all were in the dairy section of that Sam's Club when she was walking towards you and fell on water.
Y los dos de ustedes estaban en la sección de leche en el Sam's Club cuando ella estaba caminando y se cayó en agua.
Sí.
Yes.
And your daughter was injured as a result of that fall.
Y su hija fue lesionada como resultado de esa caída.
Sí.
Yes.
On the same day, you took your daughter to Methodist Dallas Medical Center.
Ese mismo día, usted llevó su hija a Methodist Dallas Medical Center.
Sí.
Yes.
And she saw the emergency room doctor.
Y ella miró al doctor de emergencia.
Sí.
Yes.
And x-rays were done.
Y hicieron radiografías.
Sí.
Yes.
The doctor said that the result of the x-ray was that there was no fracture.
El
Is that
doctor, El doctor dijo que el resultado de los radiografías fue que no había una fractura. ¿Eso es correcto?
Sí.
Yes.
The doctor said that your daughter suffered a muscle injury and prescribed ibuprofen.
El doctor dijo que su hija sufrió una lesión del músculo y le dio ibuprofen.
Sí.
Yes.
The doctor also told you that if your daughter continued to have problems, to seek an outside doctor to treat her.
Y el doctor también le dijo que si su hija tenía más problemas, que vaya a otro doctor para que la trate.
Sí.
Yes.
Over the next 12 days, your daughter complained of headaches and pain to her neck and back.
Sobre los siguientes 12 días, su hija se quejó de problemas con la cabeza y problemas con su espalda.
Sí.
Yes.
So you and your husband, Mr. Juan Martinez, decided to take her to a clinic.
So usted y su esposo, el señor Juan Martínez, decidieron llevarla a una clínica.
Sí.
Yes.
On March 25th, 2019, you took your daughter to Accident and Injury Chiropractic Clinic.
El 25 de marzo 2019, usted llevó su hija al Accident and Injury Chiropractic Clinic.
Sí.
Yes.
Your daughter underwent x-rays and an MRI to her neck and to her lumbar.
Su hija fue bajo radiografías y MRI a su pescuezo y la parte bajo de su espalda, lumbar.
Sí.
Yes.
The doctor gave you the results saying that your daughter had a soft tissue injury and muscle spasms.
El doctor le dio los resultados que fueron que fue tejido, soft tissue injury. And what was the other part of your question? I apologize.
Soft tissue injuries and muscle spasm.
Tejido sorry.
I always use the word que los músculos estaban tensos.
Sí, los músculos estaban tensos, soft tissue injury, suave tejido, lesión, y los músculos estuvieron tensos.
Sí.
Yes.
The doctors recommended and your daughter underwent 20 therapy sessions.
Los doctores recomendaron y su hija fue bajo de 20 sesiones de terapia.
Sí.
Yes.
On April 23rd, 2019, your daughter was released from her doctor's care.
El 23 de abril 2019, su hija fue acabó su tratamiento bajo los doctores.
Sí.
Yes.
And you and your husband, Mr. Juan Martinez, were agreeable with that decision.
Y usted y su esposo, el señor Juan Martínez, estuvieron de acuerdo con esa decisión.
Sí.
Yes.
Since April 23rd, 2019, it is a true statement to say that your daughter has not needed any further medical treatment.
Desde el 23 de abril 2019, es verdad que su hija no necesitaba tratamiento.
Sí.
Yes.
And your daughter has recovered completely from her injuries.
Y su hija ha recuperado completamente de sus lesiones.
Sí.
Yes.
She is 11 years old today, correct?
Ella tiene 11 años hoy, ¿correcto?
Sí.
Yes.
She's very smart and does very well in school.
Ella es bien inteligente y hace cosas buenas en la escuela.
Sí.
Yes.
In fact, she wants to be a lawyer like Judge Hoffman and Ms. Nieve and myself and Ms. Martinez, correct?
Y ella quiere ser abogada como el juez Hoffman, la abogada Victoria, Ms. Guerrero y Ms. Martínez, ¿correcto?
Sí.
Yes.
And she is sleeping fine. She's eating normally. She's growing normally, and she plays fine.
Ella está durmiendo bien, está comiendo normal, está creciendo normal y ella también juega normal.
Sí.
Yes.
You and your husband hired my office to pursue this claim against Sam's, correct?
Usted y su esposo obtenieron mi oficina para seguir el reclamo contra Sam's, ¿correcto?
Sí.
Yes.
And we in fact did that. And after a period of time, I came to you and your husband and we discussed various offers.
Y nosotros hicimos eso y después de un tiempo yo regresé a usted y su esposo y hablamos de varias ofertas, ¿correcto?
Sí.
Yes.
Finally, we discussed the final offer and your options.
Y finalmente hablamos de la oferta final y sus opciones.
Sí.
Yes.
I explained that the final offer would be $16,097.
Yo expliqué que la oferta final iba a ser $16,000 con $97.
Sí.
Yes.
I explained that the emergency room, hospital, doctors, and x-rays had been paid by Medicaid.
Yo expliqué que los biles de emergencia del cuarto, el hospital, los doctores y los radiografías fueron pagados por Medicaid.
Sí.
Yes.
And we have a Medicaid lien of $258.69.
Y tenemos un lien de Medicaid de $258 con 69 centavos.
Sí.
Yes.
I explained that the clinic had a bill of $7,076, but only $3,250 would be paid to pay that account in full.
Yo expliqué que la clínica tenía un bill de $7,076, pero solamente $3,250 era la cantidad para pagarlo en total.
Sí.
Yes.
The x-rays were $346, but we're going to pay only $100.
Los radiografías fueron $346, pero solamente vamos a pagar $100.
Sí.
Yes.
And for the 2 MRIs, the original bill was $5,995, and we are going to pay only $2,500.
Por los 2 MRIs, el bill original era $5,995 y solamente vamos a pagar $2,500.
Sí.
Yes.
So as a result of those payments, your daughter is going to end up receiving, let me get to, her share will be $4,994.16.
So, como resultado de esos pagos, su hija va a recibir $4,994.16.
Sí.
Yes.
And I explained to you what your options were with regards to that offer.
Y yo le expliqué a usted sus opciones sobre esa oferta.
Sí.
Yes.
I explained to you that you could settle the case for that amount if you felt it was in the best interest of your daughter.
Le expliqué que usted podía llegar a un acuerdo por esa cantidad si usted creía que era en el mejor interés de su hija.
Sí.
I explained to
Yes.
you that, I explained to you also that you could turn down that offer and take the case to court.
También le expliqué que usted puede
Negar.
derrotar esa oferta y llevar su caso a la corte.
Sí.
Yes.
And I explained if you chose that option, there would be quite a bit of risk.
Y le expliqué si usted escogía esa opción, iba a haber un poco de riesgo.
Sí.
Yes.
I explained that your daughter could end up getting nothing, the same, a little less, or a little or more.
Le expliqué que su hija podría recibir nada, lo igual, un poquito menos o más.
Sí.
Yes.
And after our discussions with you and your husband, we all felt it would be in your daughter's best interest to settle this claim.
Y después de hablar con usted y su esposo, todos sentíamos que era en el mejor interés de su hija resolver este reclamo.
Sí.
Yes.
You also understand that you signed, you and your husband signed certain paperwork with regards to this case.
Usted también entiende que usted y su esposo firmaron documentos o papeles sobre este caso.
Sí.
Yes.
And we went through it page by page, correct?
Y también lo revisamos página por página, ¿correcto?
Sí.
Yes.
And that paperwork reflects the agreement that we've already put on the record today.
Y ese papeleo refleja el acuerdo que ya hablamos en el record hoy, ¿correcto?
Sí.
Yes.
And you understand if the judge approves this settlement, that particular amount of money that we discussed for your daughter is going to be put in the registry of the court.
Y usted entiende que si el juez va a aprobar esta cantidad particular, que esa cantidad va a ser depositada en el registro de la corte.
Sí.
Yes.
And that you and your husband will not have access to that money without some further order of the court.
Y usted y su esposo no van a tener acceso a ese dinero sin un orden de el corte, si otro orden de la corte.
Sí.
I didn't hear her.
No escuché su respuesta.
Sí.
Yes.
When your daughter turns 18, she will have full access to that money.
Cuando su hija cumple 18, ella va a tener acceso total a ese dinero.
Sí.
Yes.
And you are agreeable with that arrangement.
Y usted está de acuerdo con ese arreglo.
Sí.
Yes.
Have you had an opportunity to ask me of all the questions you've had?
¿Usted ha tenido oportunidad de preguntarme a mí todas las preguntas que usted ha tenido?
Sí.
Yes.
And have I responded with answers to all your questions?
Y yo respondí con respuestas a todas sus preguntas.
Sí.
Yes.
Are you satisfied with my services?
¿Usted está satisfecha con mis servicios?
Sí.
Yes.
At this time, plaintiff will pass the witness.
Okay.
All right, Ms. Martinez.
Sí.
Ma'am, you
Sorry,
understand,
Ramona Martinez, I'm sorry.
ma'am, you understand that you've instructed your counsel to pay the medical providers that she outlined earlier.
Señora, ¿usted entiende que usted le dijo a su abogada que pague los biles médicos de que hablaron antes?
Sí.
Yes.
And that those payments will come out of the total amount of settlement of the $16,097.
Y esos pagos van a salir de la cantidad total de $16,097.
Sí.
Yes.
You understand that if the judge approves this settlement and enters the judgment, that you cannot seek any additional funds in the future against Sam's.
Usted entiende si el juez va a aprobar este acuerdo, usted no puede pedir fondos adicionales en este caso.
Sí.
Yes.
And you understand that your daughter in the future, when she turns 18, cannot seek any additional funds against Sam's for the injuries related to this accident.
Usted entiende que su hija, cuando ella cumple 18, no puede pedir fondos adicionales por sus lesiones en este accidente.
Sí.
Yes.
And you understand if for some reason there are any past medical expenses or future medical expenses that resulted from the treatment of this accident, that you will be responsible for those.
Y usted entiende que si en el futuro, I was trying to take notes, I apologize. Usted entiende si en el futuro, si usted quiere pedir que paguen biles por el pasado o en el futuro resultados de las lesiones de este accidente. What was the last part of your sentence, your question?
You will be responsible for those medical.
Usted va a ser responsable por esos.
Sí.
Yes.
We'll pass the witness, Your Honor.
Ms. Nieve, do you have any questions, and how do you want to handle that since you're doing translation?
I can be super brief since they covered most of it.
Okay.
Okay. And I'll do it in English and then Spanish.
Okay.
Ms. Martinez, I met virtually via video conference with you, your husband, and your daughter. Is that correct? Ms. Martinez, yo hablé con usted por conferencia, por video, con usted, su esposo y su hija. ¿Es correcto?
Sí.
And you understand that I do not represent you, and I was appointed by the court to represent the best interest of your daughter. Is that correct? Y usted entiende que yo no la represento a usted. Yo fui, la corte me puso a mí para representar los mejores intereses de su hija, ¿correcto?
Sí.
Y hablamos, and we spoke about the funds that your daughter wants to use those for her educational expenses once she turns 18. Is that correct? Y hablamos que su hija quiere usar ese dinero para sus costos de educación cuando ella cumple 18, ¿correcto?
Sí.
Yes. And you believe that this settlement is in the best interest of your daughter. Is that correct? Y usted entiende que este acuerdo es en el mejor interés de su hija, ¿correcto?
Sí.
Yes. Pass the witness, Your Honor.
I have nothing further, Your Honor.
Miss, the plaintiff, Miss Martinez, not Miss Ramona Martinez, do you have any questions for me?
Ms. Martinez, ¿usted tiene preguntas para el juez?
No.
No.
Okay. All right, Ms. Nieve, do you have a recommendation?
Yes, Your Honor. I respectfully request that the court approve the proposed settlement as in the best interest of the minor. I electronically filed a guardian ad litem report that details the medical bills. There was one that I missed, but that information was included via the testimony today. And respectfully ask that the court approve it, and also respectfully ask that the court approve my guardian ad litem fees in the amount of $1,405. I've conferred with defense counsel who approves the fees as well.
Is that correct, Ms. Ramona Martinez?
Yes, it is, Your Honor.
Okay. The court will approve the settlement as requested by the guardian ad litem. Thank you for your service, Ms. Nieve, and you guys are excused. You guys have a great day. I just signed the agreed final judgment. I didn't see a separate order for guardian ad litem fees. You can submit that if you like, and I'll sign that as well. And
And
again,
there's a line. Oh, I apologize, Judge.
I know there's a lot.
Okay.
The legislature passed a rule that at least the judges here interpret as there needs to be a separate order on guardian ad litem fees. I don't know if that's accurate or not. I don't necessarily require that, but if you feel like you need to do that, you can do that, and I'll sign that as well. But I've signed the judgment that includes the guardian ad litem fees.
Okay, thank you, Judge.
All right, guys, thank you so much. You guys be safe, okay? Good to see you.
You too, Judge. Take care.
Thank you, Your
Ms.
Honor.
Martinez. Okay, let's, anybody here on the Canon USA versus Dallas Central Appraisal District case? Anyone here on the Lori Industries LLC versus Dallas Central Appraisal District case? Is anyone here on Misty Harvey versus Performance Food Group case?
Yes, Your Honor.
Andrew Cooper on behalf of defendants, Your Honor.
This is Matt Greenberg
Food
on
Group.
behalf of plaintiffs.
Okay. All right, let's go on the record on cause number DC 1900466, Misty Harvey versus Performance Food Group. Counsel, make your appearance.
Matt Greenberg for plaintiff Misty Harvey and Ronald Schillinger.
Andrew Cooper on behalf of Defendant Performance Food Group Incorporated, Your Honor.
All right, let's go ahead and proceed.
All right, Your Honor. Well, we have come to a Rule 11 agreement that resolves this motion.
Oh, great. Do you want to announce that on the record, or you just want to submit that later?
We can just file the Rule 11, Your Honor. It's signed.
Agreed.
Okay, great. Does that obviate the need for a hearing?
Yes, Your Honor.
It does, Your Honor.
That allows me to catch up a little bit. This has been a very busy morning, so I'm glad you guys worked it out. You guys have a great day. You be safe, okay?
You too. Thank you.
Thank
Bye.
you very much, Your Honor.
All right, Zubarek versus Gonzalez.
Yes, Your Honor. Robert
So-
Miller on behalf of Mr. Zubarek.
And I see Mr. Gonzalez. We usually have a whole troop of folks here for this. Or are we not going to have that in this today?
It's their
I'm not
motion,
sure, Your
Judge.
Honor. I'm not sure, Your Honor. It is my client's motion, however.
Okay, well, let's go on the record then on DC 1918220, Zubarek versus Gonzalez. Counsel, make your appearances.
Your Honor, Braulio Gonzalez
Robert.
Let's let Mr. Gonzalez go.
Your Honor, Braulio Gonzalez for defendants, the First Amended Phillips Family Trust, Eric Sorensen, Jamie Sorensen, David Smelser, and Lindsay Smelser.
Mr. Miller?
Robert Miller on behalf of plaintiff Charles Zubarek, Your Honor.
Okay, this case was set for hearing at 11. So it's not quite 11 yet. I thought it was set at 10:45. Why don't we go ahead and wait a few minutes just to give other people an opportunity to show up if anyone else is going to show up.
All right, Your Honor.
And I think Mr. Fell, who's in this, has also just shown up. Mr. Fell, are you there?
I am here, Your Honor. Good morning.
Good morning. I understand that you guys, we've already made announcements on this. We haven't started the hearing yet. So if you just want to make your announcement on the Zubarek case.
Oh, sure thing. Good morning, Your Honor. My name is Greg Fell. I represent defendants Francisco and Marianne Gonzalez.
Okay. I think we're still missing Mr. or Mrs. Milligan. So we'll wait until 11 to get started or until they all show up, unless you guys know that this person's not coming. Do you know one way or the other?
I don't know.
that.
I would expect him, Your Honor, but I don't know.
Okay, we'll just wait.
What's the time? There's no time on this.
Mm-mm. Well, beats me how I get you in there. There we go.
No, he didn't go later, I guess.
Yeah. Okay.
If you need me now.
Who knows? Court reporter.
I think we maybe want to give up. Or do you guys want to wait? We only have 15 minutes for this hearing.
I think we can go ahead, Your Honor.
Okay, let's go ahead and proceed. And if Mr. Milligan, is it Mr. or Mrs. Milligan?
Mr.
Mr. Milligan shows up, we'll go ahead and let them into the Zoom room. So let's go ahead and proceed.
All right, Your Honor. This is a pretty straightforward motion to compel. Defendants, my clients, the First Amendment Family Trust, the Sorensens and the Smelsers sent discovery requests to plaintiff in July 31st of this year. Their responses were due to all our requests for production and our interrogatories on August 31st. Mr. Miller had requested days before the 31st deadline. He requested additional time as he wasn't completely sure that he could due to being having a lot of cases. We agreed on a Rule 11 to extend the date of the responses being due, and still Mr. Miller responded to the interrogatories 8 days late after that deadline. His response to interrogatory number 2 is the one that we are trying to compel him to answer, and answer properly, Your Honor. We're not trying to get anything but a proper response. Interrogatory number 2 is requesting the names for him to identify the 10 names which he says in his third amended petition that plaintiff is representing in this lawsuit. So we're asking to know who those 10 homeowners that they are representing are. Mr. Miller did not object. He waived his objection by responding late. Additionally, the response that he gives, which is that Mr. Sabarik denies to respond because he's afraid of some retaliation by defendants, is inadequate, wholly inadequate. It's a relevant interrogatory based on their petition. And we requested the court make them answer it. They can't object. He waived those. So that's moot.
Response?
Your Honor, it doesn't say that I represent those people. I don't. And the only reason it was in the original petition was to show that this was not some kind of grudge again by Mr. Zubarik against anybody else. It was there so that it was understood that there were more people involved who were interested in it, but did not want to become parties to the lawsuit. And the reason he refuses to give the names is in the past, and he's here today, and he can tell you that in the past, these people have been harassed. And there's just no reason for it. I have yet to see why it's important that they know who these people's names are. What does it help their case? What happens with it? Absolutely nothing, Your Honor. So there's no reason to enforce it.
Your Honor, it was important enough for him to put it in his petition. And the petition says that Mr. Subarik is representing. I'm not saying Mr. Miller is representing those people. I'm not saying that. It's saying that he's representing them. They use that language. But if he wanted to say that there was more people in the association who wanted to bring complaints forward, he shouldn't have worded it that way. It's his petition that this interrogatory is based of.
There's a Mr. Kramer that just showed up. What case are you here for, sir?
I'm here for this case, Your Honor. I apologize. I had a Zoom link issue. I have Valley.
And who do you represent?
Valley Park Estates, HOA.
Okay. All right. So I'm going to grant the motion to compel and order that it be answered within the next, interrogatory number 2 be answered within the next 2 weeks. Okay.
Your Honor, can we get attorney's fees since I had to go through this whole hearing to get Mr. Miller to respond to this?
one of the frustrations that a lot of attorneys have with me is I almost never grant sanctions. So I do if there's a pattern of misconduct, which I haven't seen in this case. And so I'm not going to grant attorneys.
I understand, Your Honor. I understand.
But do you have go ahead and get an order together that reflects my rulings, share it with Mr. Miller, and try to get it to me by this Friday.
I'll have it to you by the end of today, sir. Thank you.
Sounds great. Thank you so much. You guys have a great day.
Thank you, Your Honor. You as well.
Could I ask you another question? There was a motion to sever, and I submitted an order from our last hearing, and I haven't seen it that you signed it yet. So
let me take a look at it. Oops. When did you submit the order?
back on November 25th. Just a minute. I had talked to Rhonda.
I see it. I think November 23rd. Let me just.
Yeah, that sounds about right too, Judge.
Does anyone have a problem with this order? Anybody have a problem with this order? You guys need to respond. Anybody have a problem with this?
I think the last version that Mr. Miller submitted, we don't really have a problem with it, but I'm only speaking for me and my client.
So one thing about these types of severances, and we're about to have a hearing on this right now. Maybe you guys could tell me, Ms. Pettit, do you need to have a new cause number to enforce the severance?
Your Honor, the short answer is the local rule says that the plaintiff's attorney is required to pay it. However, there is case law from the Texas Supreme Court and the Dallas Court of Appeals that state that the severance is effective upon upon signing by the court and isn't conditioned upon payment of the fee or a new case number. Granted, none of those cases specifically addressed our local rule. So I think there could be a distinction there, but Texas Supreme Court's pretty clear.
So anyway, that's at least Ms. Pettit's view of the law on this, and she's about to have an argument about that. So you might want to change this order and include a new cause number and pay the severance fee to clarify any type of issue with it. That's how I usually require it if I catch it in the severance order and I notice this one doesn't have it. So you probably want to go ahead and resubmit it with a portion that says that you're going to that it's severed into a new cause number and that case should be closed. That'll make it a lot cleaner. All right, Mr. Miller.
So you wanted to say there will be a new cause number.
Yeah. So where it says here, what we usually do it is therefore ordered the paragraph 19 is be severed from other claims contained in the third amended petition filed on June 16th. And that this something along the lines of, and this new case will be, or this severed case will be cause number and then put a blank, and then the clerks will pay you have to pay the clerks for the severance fee, and then that will include the new, and they'll put in the new cause number there. So you'll have to pay the severance fee and talk to them about that. But
There's going to be 3 different new cause numbers then.
is that right? There's 3 different cases that are being severed in it.
Well, there's 2 cases being severed.
There's one claim being severed out to an independent case. That'll be a new cause number. The case that we're in still will continue being the same cause number.
Yeah, but I've got the cross action against Mr. Suberik.
That will stay in the original case.
I don't want it in the original case. You can't get a final hearing after that, if that's still in there, because it hasn't been decided.
So let me just make it clear. So anything that there should be 2 different cause numbers, one with the active cases and one with the cases where I've granted summary judgment, and that those would become final.
Correct.
So there should be 2 different cause numbers, the active and the inactive.
That's our understanding, yes.
The deck, Mr. Miller, the deck action that he already ruled on that summary judgment weeks ago, that becomes a new cause number. The third party claim that we have against the HOA and the HOA's cross claim against your client stay in this cause number that we're in a hearing for.
Because
right
I haven't granted a summary judgment as to that, correct?
Correct.
Yeah, so if it's an active claim, it should stay in this case. The cases I've granted summary judgment on should go into a different cause number, and then those cases will be closed or finalized, I guess.
Be final, correct.
So you want me to, and I can still sever out the claim for attorney's fees, though.
Have I ruled on that or not?
No, you have not, Your Honor.
Not.
Yeah, there's no reason to sever this out unless there's a final ruling on it.
Correct. And Your Honor, you already made this ruling.
Well,
You already ruled you were severing out the summary judgment that has already been decided.
That's right.
But if I sever out the summary judgment part, and I don't sever out the claim for attorney's fees, because you're going to say that everything is decided in the case that you ruled on, but the attorney's fees haven't been decided yet.
Correct.
That's not correct.
Your Honor, there's a separate attorney's
Yeah,
fee.
just because I sever out this doesn't mean that you can't still recover attorney's fees on it.
Well,
It
they
doesn't,
haven't.
unless
They
I've
haven't.
ruled on that issue.
You haven't. You ruled on that issue, Your Honor.
I have or have not.
Have not.
No.
Oh,
Yeah,
There's a
so
motion on Friday for summary judgment on the attorney fee portion of that claim, Your Honor.
okay. I mean, let me just say this: the severance is I don't care if it severs. It just makes it final for purposes of appeal. So if there's going to be other summary judgments coming up that you think that I need to rule on, and we may be able to make those final, it may be better to wait to sever this until all of those things are ruled on. We sever what we can, and then that will allow that to be final. It doesn't make a lot of sense to sever these piecemeal. Does that make sense?
Yes.
yes.
Okay.
Okay, guys.
So I'm not going to do anything with the order right now.
I would just say go ahead and wait, unless you want me to do it now, but then you may have to pay a different severance fee for each different time you sever it.
Yeah.
Or you could, or I guess you could, it gets really complicated because you'd have a closed case and you'd want to transfer. I just think it's a lot cleaner if we just rule on whatever summary judgments are going to be. I imagine if I've granted summary judgment on this, then I'm going to give attorney's fees. So wait until at least that's decided, and then sever all that out at once. Does that make sense?
Yeah. I guess so.
I'm not sure if maybe I'm not being clear. I'm really trying to help here.
I think you are. I think we sit on it until at least the next one comes down the pipe on Friday, and then at that point,
And then sever that all out and make that into a new cause number on this Zabara case.
So the summary judgment on the original petition would be severed out in a new case number, and everything else has the old case number?
Correct.
That's typically how you do it, yeah.
Okay.
But usually, I mean, usually what happens in these situations is that you have, you wait to sever until kind of all the summary judgments are done so that you can sever out whatever is going to be final and then leave in the existing case whatever's still active. But since we're still in the middle of summary judgments, it might make more sense to wait to do the severance until all of these issues are resolved so you can sever it into one case and not have to pay numerous severance fees.
Okay.
And have like 5 different cause numbers and 5 different sets, because the severance fees are a couple $100 a piece, I think. So I would just wait, but it's up to you. All right, anything else, guys?
I'm good with waiting.
No, Your Honor.
Hey, Mr. Gonzalez, you'll get me an order on this that reflects the compel.
Yes, Your Honor, I will. I will have one to Mr. Miller this afternoon, and hopefully I hear back from him. If I don't, you'll have one e-filed tomorrow.
So e-file and an email it to Rhonda as well.
Yes, sir.
Okay, thank you guys. You guys be safe.
Thank you, Your Honor. We'll see you again this afternoon.
Okay, great. Sounds good. All right, so Versailles Dallas versus Zatoun. You guys all here?
Yes, Your Honor.
Yes, Your Honor.
Okay. We have a number of different hearings that are set at different times, I guess, on this case. So this is consolidating the previous hearing in this one. So let's go on the record on cause number DC 1815106, Versailles Dallas versus Jordan Zatoun. Counsel, make your appearances.
Julie Pettit on behalf of Versailles Dallas Inc. and BL Chamis.
Good morning, Your Honor. It's Jonathan Scott on behalf of the Zatouns, Jordan and Aaron. And with me is my co-counsel, Joe Ackles.
Hello. All right, so at the last hearing, last hearing slot today, we had a quick discussion. I'd ask you guys to do some research about this motion or this order of severance and whether or not it was required to have a new a severance fee paid and a new cause number assigned, and was wondering if you guys had a chance to look at that.
Yes, Your Honor. Would you allow me to share my screen briefly?
Yes, let me activate that. There you go.
Okay, there we go. Give me 1 second. So this case has a number of wrinkles, but I'll try to be quick about it. Are you seeing my screen now, Your Honor?
Yeah.
Okay, so the Texas Supreme Court has indicated that an order granting severance is effective when signed, and it does not by itself require the district clerk to create a separate file or separate case number. The footnote in that case indicates that the trial court can condition the effectiveness on a future event like paying fees or separate case number. So that's what the Texas Supreme Court has said. The Dallas Court of Appeals appears that they seem to agree with this because they say if the trial clerk, it's not conditioned either on the new case number. Now, what's interesting about this Dallas Court of Appeals case is they do note that in that particular case, the party had paid the filing fee. And the reason why I think that's relevant is because a local rule says that before a severed claim is assigned a new cause number, the attorney for plaintiff in the new case shall meet the clerk's requirement concerning a deposit for fees. So all that to say, we don't believe there's a Dallas Court of Appeals case on point in which the plaintiff failed to pay the fee, because the relevant cases contemplate that the fee had been paid. So I can't point you to a case that says if the plaintiff fails to pay the fee, it's not severed. But again, the Texas Supreme Court says it's effective when Your Honor signed it. Now, the wrinkle in this case is what makes this, I think, a little bit different. And Your Honor was alluding to this in the prior hearing, which is ironic. The Dallas Court of Appeals has said if the severance order contemplates additional proceedings will occur in the severed matter, the interlocutory judgment does not become final until that's occurred. So if Your Honor is going to be doing other things with these issues, then it's not final. And I think that's what we have here. So this is Your Honor's order. You severed the claims out. Then you said, and this is a highlighted part, ordered that all claims for an award of attorney's fees and litigation costs by any party are reserved and will be addressed either at trial on the merits or thereafter by the court. So I think that's, if that sentence wasn't in there, I believe that it, at least under the Texas Supreme Court, if we disregard the local rule, I think it would have been severed upon Your Honor signing this. But I think that sentence changes it. All of that said, and I don't want to switch the screen if you're still reading it.
Wait. So let me ask a question real quick. So the claims for award of attorney's fees, are those are reserved and will be addressed either at trial on the merits or thereafter by the court? Are the award of attorney's fees and litigation costs, is that associated with the versus the what is that associated with, I guess?
Well, there were competing claims, so both sides had claims. And the way I read this sentence, it says litigation costs by any party. So I think that it includes the claims that Your Honor, fees against my client for the claims that Your Honor dismissed. So I think that's going to include things that Your Honor was intending to sever from the original case. Now, one additional thing I just want to throw in there to make sure Your Honor has the full picture, of course, is that there's a recent case out from the Texas Supreme Court in which it goes to the court's intent on whether or not you intended to have a final judgment. So this case was somewhat similar, in which case the Court of Appeals went back to the trial court and said, hey, what was your intent here? And there the judge signed a clarifying order saying, no, my intent was for it to be final. And so if there's some sort of clear, unequivocal intent of what Your Honor's intended to do, if there's a subsequent order that says that, I think that's what governs. And then the Court of Appeals can't determine whether or not this was final or not. So that's the full picture that we have. So you have to look at the local rule versus what the Texas Supreme Court says versus you could clarify it at this point if you wanted.
That's actually kind of useful for me in the future, just how this should be worded, because so it sounds like if I word these in the future as it's conditioned upon the severance is conditioned upon the payment of the severance fee to the clerk and the assignment of a new cause number, then that would make the severance not effective until then. But that's not how it's worded in this particular case.
No, that's not how it's worded here. But Your Honor is correct in our reading of the footnote 3 from this Texas Supreme Court case, Nick Roberts versus Riles. And I can send that case to you later and copy opposing counsel if you want to have it. But yes, if you condition it, then it is certainly not effective until those things happen.
I didn't condition it in this case, except for possibly this argument about attorney's fees. Is that right?
Correct, Your Honor. I'll put the order back up so you can see it.
Yeah, why don't you keep the order up? All right.
Can I respond, Your Honor?
You may.
Our research uncovered the same Texas Supreme Court case. But I'd like to, rather than reading from the blurbs at counsel, I don't know what the source is, but that looks like a secondary citator or reference to the actual Texas Supreme Court case. I think the language may be helpful to Your Honor. I agree with counsel. What the Texas Supreme Court case.
Why don't you share screen that so I can see it?
Absolutely. Can you activate that?
Yeah, I'll go ahead. Yeah, go ahead.
Okay. It's requiring me to unlock something, Your Honor, in order to share a screen. Apologize.
I have it up if that would be easier. It looks like you have it now.
Yeah, why don't you share it then? If he can't get, he can't share it.
Sure. It's up. Mr. Scott, if you want to tell me what pen site to go to.
It would be, thank you. It's page 3, court's ruling of the decision, rather.
I'll zoom.
Your formatting may be different, let's see.
I think ours, here we go. It's at on mine, it's the bottom of page 3, the top of page 4.
Right, so Your Honor, as counsel was saying, but the actual language specifically says in order granting a severance with a judgment of the cause ordered severed is effective when signed. It becomes effective without the district court's creation of a separate physical file with a different cause number. And this procedurally, Judge, this was the same procedural posture where it was a summary judgment proceeding. And those claims, those affirmative claims by the plaintiff, in this case Versailles, were all disposed of on summary judgment. And the order severing, in our case, the counterclaims, those were the ones that remain to be tried. There really is no claim by Versailles for attorney's fees because they lost the case on their contract claims and they lost on summary judgment. So all your order was intending to do with regard to reserving attorney's fees is to make it clear that our application for fees as the prevailing party, that would be
what causes of action allow for attorney's fees in this by both sides? Is it just a breach of contract or is there a declaratory judgment on both sides?
Your Honor, the Versailles pleading was just with regard to breach of contract is what they claimed.
Mm-hmm.
Our counterclaims claim breach of contract. We have a DTPA claim. We have a fraudulent lien claim. We also have a federal RICO claim that provides for attorney's fees. So
there's the reason I ask about the declaratory judgment, that's the only cause of action that I'm aware of that either side could get attorney's fees, either the prevailing party or the non-prevailing party. So if they don't have a declaratory judgment, then I don't see how they would have an attorney's fees claim.
Just to be
okay,
clear,
so
I think it would be their claim against us for fees that was still pending.
Okay, that makes sense.
And Your Honor, I would also mention that I went back and looked at the clerk's docket, and the clerk of the court did give notice of entry of judgment in this case by letter dated October 26th that was sent to all counsel, indicating the judgment had been entered on October 19th, which is the date of your summary judgment order. So we do agree, based upon the reading of this case, that a new file should be established with regard to the remaining claims, which are the Zatoun's counterclaims, and we will get with the clerk and pay the fee. They certainly never requested that of us, and we believe that when Your Honor signed the order that the severance was effective and that their claims against the Zatoun's are final and appealable.
So let me ask a question here, because this is one of the disadvantages of doing this over Zoom, because I guess I could pull it up over here. What day was the motion for motion for new trial filed?
It was timely, Your Honor. It was filed within 30 days. It was filed November 18th, 2020. And
okay,
your order granting the summary judgment was signed on October 19th.
Okay. All right. Well, that kind of clarifies that. So it is a timely motion for new trial. I do have plenary power to hear it. So let's, I guess, get to the meat.
Thank you, Your Honor. I will be as brief as I can. So this is again, I styled it both ways because I didn't know what the court's intent was as far as whether that was final. So I've styled it as a motion for new trial or alternatively, a motion to reconsider. And if Your Honor will allow, I have a couple of things I'd like to put on the screen if I can still share my screen.
Yes, you may.
So I know Your Honor may have already have the background of this, but by way of background, Mr. Zatoun, who is the defendant, I guess now the only one with the affirmative claims, he's an experienced individual in real estate and construction, and his mentor is my client, Sam El-Chami. So what happened was Mr. Zatoun was wanting to build this dream house, but as I'm sure Your Honor is aware, you're not technically allowed to be the builder of your own home. So he went to his mentor, Mr. El-Chami and Mr. El-Chami's son, and said, I want to build my own house, but I have to have a construction company behind it so that I can get a loan. So they entered into essentially a gratuitous contract where my client said, sure, you can put our name on it. We understand you're going to be doing the work. You're going to be the one there on site every day, but you can put our name on it. And they had to do that in order for Mr. Zatoun to get his bank loan from Prosperity Bank. So the parties enter into this gratuitous contract. They say, yeah, put our name on it so you can get your loan. They sign this contract and everything is underway. Opposing counsel's clients understood that whole time, everyone understood that my clients were never going to make a profit on this house. There was no profit. There was nothing for my clients to make. They were simply doing this as a favor to Mr. Zatoun, who was his mentee essentially. So this goes underway. They run into some hiccups, as often happens, where the city didn't approve some of the items that needed to be approved. So they initially got the loan as planned, but then the city of Dallas doesn't approve it. At that point, costs went up. My clients, again, out of the goodness of their heart, said, look, we're friends. We'll keep helping you out on this. We'll front the money. We know you don't have it and you're not getting your finances. We'll continue to front the money. So my clients, again, as a favor, fronted roughly $112,000, I believe, and all this is in the summary judgment evidence, to help these people out. So they move forward. There's emails in the record that I'm sure Your Honor has seen where Mr. Scott's clients continue to assure my clients, hey, you're going to get paid. Thank you. We're going to pay you. Don't worry. It's going to work out. All parties at that point knew that my client, to protect their interest, was going to file a mechanics lien. This happens all the time. You've got someone that's advancing costs and doing work on a house, they file a mechanics lien. So my clients filed a mechanics lien. Everyone's aware of it. And then that's essentially what I think was, and I wasn't at the prior hearing, but what I think may have been not as clear is the fact that there are two separate transactions, and it's important to make sure that we're clear that there are these two separate transactions. So the first one, again, there's a mechanics lien filed. That's transaction one. This mechanics lien is filed so that when the payment is made from the lender, my client gets paid. So that happens, but that wasn't the full amount that was owed. So there's a mechanics lien paid, a release is signed, and $40,000 goes to my client. That was a portion of what was owed. And what's important to note is that release, that first release that I just mentioned, that's what this motion for summary judgment was based on. The one that Your Honor granted is based on the language in that first release, that May 17, 2018 release. When you look at their summary judgment motion, it's very clear they're moving on that May 17, 2018 release. That's the first transaction. I agree that first release was signed and released everything that would have been due as of that point. But then the parties chose to continue and enter into a second transaction. And I think that's what wasn't clear. There was a second transaction after the first one when everyone knew money is still due. And I'll put the evidence up on the screen. I know this text is kind of small, but after that first release was signed, the parties agreed that there's still $76,000 owed. And so they do a new note, a brand new note. Mr. Scott's client gives my client a check, which turns out to be a hot check. All of this happened after that release was signed. And I'll put the dates up with the actual instruments that you can see. So that the original release was in May. It's in June when the parties do this new second transaction. So Here is the May 17, 2018 release that the motion for summary judgment was based on. After that point comes transaction 2, which is June 14, 2018, that they signed, promising to pay this additional $61,000. And my clients, as part of this transaction, said, yes, we'll release you from everything moving forward if you pay us the $61,000. Part of that was a down payment of the $14,000 check that was a hot check. This is the second transaction that cannot be subject to an earlier dated release. So when they sign this, this promissory note and give my client the $14,000 check that turns out to be hot, my clients issued the second release because that was all part of that second transaction. They have 2 arguments, Your Honor, in their summary judgment motion. The first one is that this, and this is up on the screen, that the May 17, 2018 release bars the promissory note. That's not the case. Parties can agree to finish one deal and enter into a second deal, and that's exactly what happened here. The first transaction was over and released, and then they separately later promised to pay this amount, the $61,500, with the hot check and the release that came as part of that second transaction. So that's one of their 2 arguments in their summary judgment motion that was granted. The second argument is they say that there was no consideration for the promissory note. I put on this slide, the promissory note on its face clearly says for value received, borrower does X. There's straight black letter case law from the Dallas Court of Appeals with that exact same phrase that says when you say for value received, that is sufficient consideration. You don't need anything more. It's the same exact language on our promissory note as the Dallas Court of Appeals case. And then separately, on the consideration issue, I've put case law on the screen from the Dallas Court of Appeals that if they had not verified this defense, it's waived. They have not verified to date any of their affirmative defenses in this case. So they should not have been able to prevail on summary judgment on this particular issue because it wasn't verified. So for those reasons, Your Honor, we believe that there are at least fact issues that should be decided at trial regarding these releases and the hot check. Again, my clients only filed suit. My clients were the original plaintiffs. They only filed suit because that $61,000 note wasn't paid on and the $14,000 payment toward it was tendered insufficient funds. So we believe that these are issues that should be decided at trial. Thank you, Your Honor.
Response?
Your Honor, let me address, if I might, the argument with regard to the pleadings. So there's a Supreme Court of Texas 2019 case on this issue. This is a new argument by counsel that was not raised in the summary judgment motion. The argument claiming that the matter of lack of consideration was not properly before the court on our summary judgment hearing. And what the Supreme Court of Texas in the Goody versus Wells Fargo case, which is 575 Southwest 3rd 531.
Can you share that? Share screen.
Unfortunately, I have only can I send a copy of it to you, Ronna?
I guess so.
I can probably pull it up pretty quickly, Your Honor, if you would prefer.
Here's the language, Your Honor, that I'm relying on. This was a case in which an argument was made that there was a defect in the pleading because the defense was not properly pled. And the Texas Supreme Court says, we agree with the dissenting justice in the Court of Appeals that under our decision in Roark versus Stalworth Oil and Gas, Wells Fargo waived Goodoff's alleged pleading error by not raising it in the trial court prior to judgment. Wells Fargo did not alert the trial court to Godsby's alleged pleading defect during summary judgment proceedings or at any time prior to the judgment. So as we've talked about before, we had a judgment that was entered. This is a new unpreserved argument. And I would point out, Your Honor, that if former counsel had raised this in response to our second motion for summary judgment, we would have had the client sign another affidavit verifying the no consideration defense. But what counsel also did not cite to in summarizing Rule 93 is that Rule 93 says, unless the truth of the matter appears in the record. And our summary judgment record which started with the first motions for summary judgment, included affidavits from both of my clients denying that they received this loan or any consideration.
Let's talk about this Goody case, and if there's any way that we could share it, that would be great, so I can look at it. But so is the Goody? I guess the issue here is, was this waived because they didn't bring it up in the summary judgment response? Can they bring it up in the motion for new trial? Was that addressed in the Goody case, or?
The Goody case deals with is it waived by failure to plead it in the in the argument of the summary judgment, and before entry of judgment on the summary judgment.
Well, I'm pulling it up now, Your Honor, if you'll give me just a second. But regardless, either way, it's our position that the judgment wasn't final because Your Honor made a carve out for future proceedings. I almost have it up. Give me 1 second.
Your Honor, I would also point out, if we're looking at this issue fresh, we filed an answer to a response to their new answer on Friday that re-verifies by the clients the defense of lack of consideration. So if we're talking about now, it's an academic point, and previously, I think the reason why former counsel didn't raise it is because we had affirmative affidavits from the clients on this issue of lack of consideration.
So it says Wells Fargo did not alert the trial court to Godoy's alleged pleading defect during summary judgment proceedings or at any time prior to judgment. And then rendition of judgment. When exactly is rendition of judgment? Does that mean prior to, can it be raised in a summary? I guess, can it be raised now, or did it have to be raised prior to the time I signed the judgment?
Your Honor, our view is that rendition of judgment means entry of judgment. Here we have a notice of judgment by the clerk on October 26th to all counsel. So in our view, that would be the latest time. And on a motion for a new trial, in the absence of newly discovered evidence, which this does not qualify, new arguments are not the basis for a motion for new trial. This is not Your Honor, respectfully, new counsel coming in and deciding that they have different or better arguments that they'd like to present to the court. There has to be we get rulings whether we agree with them or not.
No, I'm not, that's not what I'm getting at. I'm just wondering, is this waiver argument, what is Supreme Court saying here? Is it waived if it's not, it says if it's not raised in the summary judgment or at the rendition of judgment?
Your Honor, Black's Law Dictionary says rendition of judgment is the judge's oral or written ruling containing the judgment entered.
So it is waived then, it sounds like.
Let me also point to something else, Your Honor, that may be easier, which is TRCP Rule 90 that counsel does not cite, says that defects in pleadings are waived if not raised using the same language prior to rendition of judgment. So Rule 90 is entirely consistent with the Texas Supreme Court ruling that this argument is waived and not properly before the court. So not only is this a new argument by counsel, this is not an argument that former counsel raised in response to our pleadings in which we asserted that there was a lack of consideration. But Your Honor, I would point out as well on the other aspect of this, waiver, absence of consideration was not the predominant focus of the prior summary judgment hearing. Prior summary judgment hearing was based upon the fact that Versailles signed a dispositive release. And Your Honor will recall during that hearing, you asked counsel who represented Versailles at the time, this is that you had reviewed it the papers before our hearing, and this was one of the clearest cut cases in which a party had signed a release. Now, that release that they signed that counsel showed you waived two things: claims for money related to the project, Maple Springs, and secondly, all lien law rights against the property. And so, Your Honor, this recitation by counsel, I want to focus on what the evidence is. And so the evidence in this case, we've been litigating this case for a long, long time. Go back to when we were in front of the court in March of 2019. Mr. Ertl was counsel, and he told the court that this claim for $76,000, the $14,000, this is all in the reporter's transcript, the $14,000 and the $61,000 promissory note was a claim for extras or additional sums under the original contract. So I know new counsel is taking a different view of things, but the reality is that they've said over and over again that this is a claim for extras related to the property. And they signed a release unequivocally with the bank on May 17th, 2018, in which they waived their lien rights and they waived any rights to additional money. Your Honor has been all through this, and there has been nothing clearer. They also argued, Your Honor, you'll recall at that summary judgment hearing, that these emails between the parties, that somehow indicated that there was a debt that was still owed or a promise to pay on a new debt. And Your Honor made the observation that those emails were all dated prior to the date that they signed the release. So you asked at the prior hearing, you asked counsel, do you have anything any record evidence that would establish that that new work was done, or that there's some other consideration that was given, that my clients received something, and counsel had nothing to present to the court? I would also point out, Your Honor, that while I appreciate counsel's take on what happened in this case, that's just their client's statement. And what Versailles is asking the court to do is to say that the builder contract, which they signed and sent to Prosperity Bank, in fact, is not what it purports to be. That it was, they referred to it as gratuitous, but essentially what they're saying is, we made up a phony contract, and that's how we got $507,000 paid by the bank. But I'd also point out one other thing on the evidence as opposed to the arguments of counsel. Your Honor, they are claiming that they did all of this work gratuitously and that they were owed an extra $112,000 for out-of-pocket costs. A party who was in that situation, who owed money, who spent money and supposedly did a favor, would not have mandamused, Your Honor, to avoid producing the books and records, which even after the Court of Appeals affirmance, we have none of those documents. So this $112,000 number, there is no competent evidence, no receipts, no checks, no Chapter 162 residential trust account. There's nothing here. There's nothing here other than affidavits by the El Chamis that keep changing to suit avoiding accountability. It's a no merit claim.
May I respond briefly, Your Honor?
You may.
Thank you. In regard to the pleading requirement, certainly that's an argument that we threw in based on the fact that we noticed it had not been verified, but certainly the crux of our argument and our motion is the motion for new trial standard, such that we argue that the great weight and preponderance of the evidence is that this is a sufficiency challenge, based on or against the evidence that's in the record. We purposefully did not put any new evidence in front of the record or in front of Your Honor. This is simply two transactions where the parties signed a release and then later agreed to additional funds. If if it were to be the case that you can't enter into a later transaction for additional monies, builders and anyone involved in construction couldn't function. You could never do business with a party that you signed a release on.
But was there additional work done after the first transaction?
I don't want to, I cannot point, I want to stick with what's in the record. I'm not going to state what I believe the facts would show at trial. I can't point, Your Honor, to anything in the record as it is that additional work was done. I believe the testimony will be different than that, but I can't point, Your Honor, to anything in the record at this time. But what I can tell you is that if there was a release, then why in the world would Mr. Scott's clients go and sign a new promissory note, give them a hot check? Why would you, if you had been released and didn't owe anything, you're not going to go the next month and sign a new note and give someone a hot check. You don't do that if nothing is owed. It's clear, I think, from the record, there's at least a fact issue there of, well, something happened, because people don't just generally go for no reason and sign a $61,000 promissory note. And again, if you can't contract with a party after signing a release, then that kind of terrifies me for the real estate industry. And the last thing I want to comment on is just in regard to the documents being produced, Your Honor. I just
want to make it clear, so that depending on how that I absolutely agree with you, Ms. Pettit, that if there's a release and then additional work, if you sign a full release and then you enter into a new contract to do additional work, then of course you can that second contract would be enforceable. But if you sign a release and then you enter a new contract and no additional work is done, then what was the purpose of the first release?
Your Honor, I would point, Your Honor, to the record to say that I'm not aware of anything in the record that says either additional work was done or additional work was not done. I'm looking at our client's affidavit and I'm about to pull up theirs. I don't think there's evidence one way or the other as to what additional work was done during that interim period. So I think at a minimum, there's a fact issue. I hope I didn't mistake.
Don't you have a responsibility to raise the genuine issue of material fact?
Well, I think for value received on the face of the contract shows that there's new value received. We're looking at a brand new promissory note, at a later date. And they swear when they sign that there's additional value received, and the Dallas Court of Appeals has said that's enough. Exact same language, that's sufficient. The only other thing I want to say is in regard to the documents being produced. I can assure Your Honor that I will make sure that Your Honor's order and the Court of Appeals order is complied with. I have conferred with Mr. Scott on a motion for protective order, since we're talking about tax returns and things of that nature. And it's my understanding that they are opposed to any sort of protective order on my client's tax return. So we have filed a motion for entry of protective order and intend to comply with any discovery orders that are outstanding once that's been entered by Your Honor.
Your Honor, may I respond?
Sure.
With regard to the matters of record, on the question you asked as to whether or not they did additional work, if we go back to in the summary judgment record, the first motion for summary judgment that was filed by Versailles says that the undisputed facts are that they substantially completed the project on May 16th, 2018. And then they left the project and didn't return to complete the punch list items because, according to them, the Zatoons had financial difficulties. So the summary judgment evidence that the court actually has, there is no evidence. The evidence is actually to the contrary, which is they certified to the bank, I'm talking about Versailles, that on May 16th, that was the last work they did. May 17th, they signed the release. Counsel's concerns about the impact on the real estate industry and builders, I would respectfully submit is overblown. It's very simple. If presented with a release that asked for an acknowledgement that they were paid in full on the project, they didn't have to sign that release and accept that condition. They could have disclosed to the bank that we need to carve out if we do any additional work, or we need to carve out because we claim that we're not fully paid. But there's a point at which business people in particular, they say they build multi-million-dollar estates. I'm talking about Versailles and the Alchamis that have been doing this for decades. There's a point at which the document means what it says and it's in force. And you can't have your cake and eat it too. They signed that release, acknowledged they were fully paid on May 17th after leaving the job, and they collected a $40,000 final draw from the bank in full satisfaction. And so based upon that, Your Honor, they've released these claims that they asserted in the complaint are waived and released.
Your Honor, I guess the concern to me is if they believed that they had been released and if there was no outstanding amounts owed, you wouldn't go a month later and sign a brand new note and sit down and sign your name on a check for $14,000. Parties have to be able, as Mr. Scott says, for contracts to say what they mean. And you can't go signing promissory notes and executing checks after the fact if you believed that you were released. And otherwise, I guess they could forever, now moving forward, these parties could never enter into a separate contract at a later date if one release is a good release for all time indefinitely.
Your Honor, there's a very simple answer. Counsel referenced this. Versailles filed an involuntary, non-consensual mechanics lien for $76,000, the same amount we're talking about here, with the Dallas County property records on April 10th, 2018. May 17th, 2018, they signed a release with the bank waiving all lien rights, but then they refuse to release the lien and take the position in the summary judgment motion that that was the consideration for the promissory note and the check. And so, Your Honor, the record is very clear that they were holding this mechanics lien over my client's head and refused to release it, and they've acknowledged this. And they had no right to do that because they had released the mechanics lien on May 17th with the bank. They've released their rights. And so what they were obligated to do, instead of having their lawyer draft a promissory note and demanding a check, is to unequivocally release the mechanics lien. But the Alchamis and Versailles would not do that. They refused. So that's the reason why.
So is that why your client signed the promissory note?
Absolutely.
Because they wanted to be able to release from the mechanics lien?
Yes, because of the fact, Your Honor, that they couldn't get their permanent financing with that lien in place. And they didn't know that the bank and the builder had signed this release agreement because it was kept from us for 2 years. It's never produced in discovery. We only found out about it a couple of days before the original trial setting in September when Prosperity Bank produced their loan administration file.
I add 30 seconds to this, Your Honor.
Sure.
I try to stay quiet because I don't want to be cumulative. The three lawyers that have represented these defendants, the arguments have evolved from the beginning to now. And they've evolved because they realized the contract says it has to be amended only in writing. So once they realized they couldn't amend the contract and there was no amendment in writing, these new arguments have come forth. Now it's evolved to 2 transactions. The reality is this: when you spin so hard this late in the game, things catch up with you. If we believe Ms. Pettit's argument, the Alchamis have participated in flat out bank fraud. They're telling you the original contract submitted to the bank was a ruse. They're telling you that the lien release submitted to the bank was a lie. That's bank fraud. And it was designed to get the loan from the bank. If we believe the Alchamis, they participated in bank fraud. And secondly, they've never produced a single item, although you've ordered them to do it multiple occasions. The Court of Appeals says their appeals denied. They've never produced any documents of what work they've done. Nothing. Not produced. And yet they want to come here today and say, we need another bite at the apple. We haven't been provided a fair day in court. So I submit this is nothing but spin and another creative argument, but the nest has already been made And it wasn't bank fraud. It was a legitimate loan to build a home, and the Alchamis did the building per the original loan document. That's all I have, Your Honor.
Okay. I think it was a good argument, Ms. Pettit, about the two transactions. I just feel like, you know, and maybe if you had been involved in the case back when it was originally argued and the record was developed in a different way, that maybe this, and maybe that's just the record. The record, I don't know if the record was accurate or not, but I have to base it on the record. And so based on the record before me, I'm going to have to deny the motion for reconsideration. I do have, and I'm not sure what this means, a couple of other issues. I have it, the hearing that was supposed to be at 11:15 was about opposed to witness testimony not being live and being outside discovery time limits. What is that about?
Your Honor, I think my understanding is there is a motion that Ms. Pettit filed, but I don't believe it's been set for hearing. But what prompted this, it was a request for a conference on my part because Wells Fargo Bank was subpoenaed for trial, the custodian of records. And my purpose in doing that was to have the custodian of records validate and authenticate various bank documents from Wells Fargo, predominantly copies of checks and bank statements in my client's accounts to show payments in this case, so we wouldn't be met with evidentiary objections with regard to the form of the evidence. And the Wells Fargo contacted me. My subpoena did not include any request for production of documents. It was a request that they bring the custodian of records to validate the records in this case that they had issued on behalf of my client. We tried to get the record certified at the branch level, and they said it has to be done through a subpoena. In response to the subpoena, I got a call from the Wells Fargo subpoena department asking me to specifically tell them what records, so that they could bring the right custodian to testify at the trial, I should let them know what the records were. And I indicated a series of checks and bank statements in my clients, either in the name of the Zatoons or in the name of Nair Management, which is another company that's involved in this case that my client is the owner of. And also the other one that was referenced in the subpoena related to Versailles. But with regard to Versailles, apparently had an account at Wells Fargo. This was merely to confirm their receipt of the wire transfers that came from Prosperity.
Okay.
And
So what am I supposed to be hearing right now? What is this?
There is no motion in front of you, Your Honor.
Okay.
I had requested a conference to discuss the release and handling of records that Wells Fargo produced on their own, presumably with, I think, I haven't seen it, but I think it's probably business record certification of those documents.
I assume, okay, so our trial setting is no longer tomorrow, it's on January 5th.
Correct.
And we moved this, I thought, Ms. Pettit, because you were going to be on your honeymoon. So are you leaving? What'd you say?
Tomorrow. I'll be leaving tomorrow, Your Honor.
Okay. So I guess my one thought on this is that just because someone's subpoenaed, that doesn't mean they come to court live. They need to be via Zoom. So you need to provide them the Zoom link on this whenever it's done. So I don't want any custodians of record showing up here live. They need to be coming via Zoom. I don't know if that addresses your issue.
I'm sorry, Your Honor, that just to clarify, that's not the issue. The issue is that your court coordinator indicated that she had received documents from Wells Fargo.
Oh, okay.
And so
I have those right here.
Okay, Your Honor, on those, we have filed a motion for protective order on those because this subpoena appears to be, at least from what I can tell, something that they're trying to serve way after the discovery period has closed, and that is just asking for documents from my client's account number. I mean, I think that's overbroad. It's not limited in scope. For whatever reason, I don't know, Wells Fargo sent them to your honor. Mr. Scott wanted them released to both parties, but we have a motion for protective order that we intend to set. I don't know what's in there, but to the extent that it's account information from my client, A, it's way outside the discovery period, and B, the subpoena is overbroad as written. It just says records concerning transactions from the following accounts, and then lists my client's name and account.
Okay, so there's nothing said, I guess, but this is what the letter says. I'm not going to read any account numbers because this is on Zoom. You know what? In abundance of caution, I'm going to take this off of Zoom or off of a YouTube.